Welcome everyone to our webinar on managing employee sickness and absence in the workplace. Hope you're all having a great morning. My name is Joel Hayden and I'm the practice leader in LegalVision's employment team. I'm joined today by my colleague Sophie Joselyn, who's a senior lawyer in our team. Before we get into the webinar itself, a couple of quick housekeeping items to go over. You will be emailed the recording and slides of this webinar, so don't feel like you need to be furiously writing notes. You can also submit any questions you have in the chat box and we'll try to get to them all at the end of the presentation. We would also really appreciate it if you could complete the survey that pops up after the webinar. We really do value your feedback on these webinars. All attendees are also eligible to receive a free consultation with us to discuss how we can help you with any of your legal needs. To request that free consultation, just provide us with your contact details in the survey that appears at the end of this webinar. So today, we're going to be providing you with a bit of an overview of employee rights and employer obligations when it comes to absences due to illness or injury. We'll then outline some best practice approaches for managing short and long-term absences. And finally, we'll give you some practical tips for dealing with absenteeism in your workplace. Sophie is going to kick us off by providing a summary of what those employee rights are in relation to temporary absences from work. Over to you, Sophie.
Thanks very much, Joel, and welcome everyone. Look, as I'm sure many of you are aware, employees have a number of rights and protections when it comes to being absent from work due to illness or injury. Now, first and foremost, the Fair Work Act provides all full-time and part-time employees with an entitlement to 10 days of personal or carers leave, also known as sick leave, for each year of service with their employer. Now, this leave is cumulative from year to year when it's unused, but it's not payable upon termination like annual leave would be. Now, your employee may be able to access paid personal or carers leave if they are not fit for work because of a personal illness or a personal injury affecting them, or alternatively, they may be eligible for the carers aspect of that leave, where they are required to provide care or to support a member of their immediate family or their household. For the purposes of today's webinar, we will be focusing on personal leave due to the employee's own illness or injury rather than carers leave. Please note that this can be used for either purpose. Now, it's important to note that there is actually no statutory entitlement to unpaid personal leave. So once your employee has exhausted their paid personal leave balance, they technically have no further right to receive any unpaid leave. However, in our experience, it's not uncommon for employees to request to use other leave balances, such as their accrued annual leave or long service leave, if they have exhausted their personal leave balance, as that is obviously sometimes better than the alternative to remaining on unpaid leave. Now, where an employee does make a request to use their annual leave or their long service leave, it's important to ensure that that request is never unreasonably refused. And if you are going to refuse such a request, you would need to have reasonable business grounds in order to do so. Now, turning to workers' compensation, your employee will not have any entitlement to workers' compensation for a personal illness or injury. However, where your employee suffers a work-related injury or illness, or even where they exacerbate a pre-existing injury during the performance of their duties for you as their employer, then they may be eligible to make a workers' compensation claim in respect of that injury and receive payments. Now, finally, the main duty that kind of ties all this together is that employees are obviously also entitled to a safe workplace in accordance with workplace health and safety legislation. And knowing then the rights and protections for employees, it's worth now taking a look at your obligations as an employer when it comes to employees being absent from work due to illness or injury. So I'll now hand it back over to Joel.
Thank you for that, Sophie. And what Sophie has made clear here is that Australia is a jurisdiction that is protective of employees who have suffered an illness or injury. And that's more so where the injury has occurred in the workplace, i.e. there is access to schemes such as the workers' compensation scheme, but also where there's no connection to the workplace, there'll still be the ability to take that sick leave as part of personal or carers leave. As you would imagine, in many ways, employer obligations in relation to this topic mirror the rights of employees. But we do think it's important for us to expressly address what other obligations there are for employers as well in this context. So beyond the reciprocal obligation on an employer to permit employees to take and be paid for personal leave when they have access to it, and to not unreasonably refuse requests of annual leave, as Sophie mentioned, many of these obligations relate to restricting an employer from taking action, including dismissal in certain circumstances in relation to an employee being temporarily absent from the workplace for medical reasons, or for exercising related workplace rights. These obligations primarily arise under the Fair Work Act, work health and safety legislation state to state, and discrimination legislation at the federal and state levels. Under the general protections of the Fair Work Act, an employer is prohibited from taking adverse action against an employee because they have exercised a workplace right, which in these particular circumstances would most likely relate to an employee being dismissed for taking personal leave or for making a workers' compensation claim, because they have a physical or mental disability, with the exception of when this is due to the employee being unable to perform the inherent requirements of their role and reasonable adjustments are being considered, or because this has been temporarily, or because they have been temporarily absent, due to illness or injury for a period of less than 3 months consecutively, or 3 months in total over a 12-month period. And it is important to remember that this concept of adverse action relates to not just dismissal, but also to any other action that either injures the employee in their employment, alters the employee's position to their detriment, or discriminates against the employee compared to other employees. The Fair Work Act also has unfair dismissal protections that would likely be enlivened if an employee was dismissed for any reason that was unlawful under the general protections, or otherwise where the dismissal was not procedurally fair. And an example of that would be where an employer has dismissed an injured employee without real consideration of reasonable adjustments that could be made to accommodate them. The various state and federal legislation also have prohibitions on dismissing employees due to disabilities and medical conditions, again with the available defence that the employee is not able to undertake the inherent requirements of their role after considering reasonable adjustments. Under state-based work health and safety legislation, there is also an extension of the prohibition period for dismissing an employee whether absent due to an injury. And this is opposed to a personal injury outside of the workplace. And an example of this is that in New South Wales, there's actually a 6-month prohibition period for dismissing an employee because of a workplace injury. So it's very important to keep that in mind when addressing illness, injury in the workplace. And what is clear is that there are many protections for employees where they are unable to perform their duties due to illness or injury. And an employer really needs to carefully consider what obligations they have on a case-by-case basis, dependent on a number of factors. And those factors include where the employee was injured, i.e. was this at work or not? How long has the employee been out of action, addressing the relevant prohibition periods? What could the employer do to accommodate them? And if there is a proposed dismissal, what is the reason for it? i.e. identifying whether there's a causal link between any of these protections we're discussing and the reason for dismissal. So it's important to consider the risks that flow from this. And the risk to an employer if they trip up on these topics can really be quite extreme, and there are a number of avenues to pursue for an aggrieved employee. One of the primary claims that we see in this area is called the General Protections Claim under the Fair Work Act. And this would be where an employee alleges they've had adverse action taken against them due to their exercise of a workplace right or protected attribute, or otherwise where they're being dismissed for a temporary illness or absence, as previously mentioned. These proceedings commence in the Fair Work Commission, but usually proceed to the federal courts and can result in outcomes including reinstatement for the employee into their prior role, potential uncapped compensation, and potential civil penalties, not just for the employer, but also for knowingly involved individuals involved in that decision. And that could be HR managers, directors, managers, anyone who's basically making a decision in relation to an employee's employment. There are similar proceedings available under discrimination legislation, and these can result in similar outcomes where the matters proceed to hearing, again in the federal courts. As mentioned before, unfair dismissal claims are also relevant, and a successful unfair dismissal claim in the Fair Work Commission may result in an employee being awarded up to 6 months' worth of compensation and potentially reinstatement into their role as well. Similarly, there are the normal obligations under work health and safety laws at the state level, and those can be prosecuted by the regulators in those states, including issuing compliance notice and actually commencing proceedings for civil penalties in courts. So what this adds up to is that it is vital that an employer gets it right when dealing with employees' injuries, illnesses, and related absences. And Sophie is going to get us started with looking at how employers can manage shorter-term absences, and then I'll address the same in relation to long-term absences.
Thanks very much, Joel. Look, it's quite clear that in circumstances where an employee has been absent from work for less than 3 months, a short-term absence is never really going to result in a reason for dismissal due to the protections that Joel has just mentioned. So the question then remains, how can you as an employer manage short-term absences? Well, I can tell you that as employment lawyers, we see a number of common mistakes that employers make when managing short-term absences. And some of the most common pitfalls that you should avoid include not having clear policies which set out the correct process for your employees to notify you of their absence or the requirement to provide you with evidence supporting such absences, not enforcing the standards set out in your policies and procedures, and just generally not managing the ill or injured employee from the first absence, as well as keeping in regular contact with the employee during their absence. Now, there are a number of steps that you can take as an employer to combat these pitfalls. And first and foremost, we do strongly recommend that you implement and maintain policies requiring your employees to notify you of their absences in accordance with your directions. So, for example, you could make it a requirement that all employees must notify their immediate manager via telephone rather than text message as soon as possible before the start of their rostered shift. Or alternatively, you might require the provision of a medical certificate if the absence is either side of a weekend or for more than 2 days in duration. Now, if your employee does not follow the evidence and notice requirements contained in your policies and procedures, this can also present an avenue for you to potentially look at taking disciplinary action against them for failing to follow your lawful and reasonable directions contained in your policies. So for this reason, it is super important to ensure that you document and address any non-compliance with your policies as it arises. Now, as I mentioned, you can request medical certificates in support of any absence due to illness or injury. And if your employee does fail to comply with that direction to provide medical certificates, you do actually have discretion as an employer to deny the employee paid personal leave. But regardless of whether your employee provides medical certificates to support their absence, once your employee exhausts their accrued personal leave, they will be on unpaid leave, unless, of course, they request to use accrued annual leave or long service leave, as we mentioned earlier. And certainly in our experience, where an employee is no longer being paid, this can often discourage them from taking further sick days in circumstances where they're not receiving any remuneration for that time off. Now, finally, we do recommend regularly consulting with your employees to inquire about their health, well-being, and general fitness for work. So, for instance, if you have detected a pattern of excessive absenteeism, your first step as an employer should always be to talk to the employee and try and pinpoint the cause of the repeated absences so that you can adopt an appropriate strategy for managing their absenteeism moving forward. Now, by doing this, you can assist with workforce planning, and it can also allow you to put measures in place to assist with your employees' eventual return to work. It also ensures, importantly, that the workplace is seen to more generally support its workers' health and well-being and comply with its obligations under workplace health and safety laws. Now, the hope is that by implementing these measures, you can really work to start resetting expectations for your employees regarding absenteeism due to illness or injury, and put clear strategies in place for managing employee absenteeism moving forward. And on that note, I'll hand over to Joel and he can walk you through some tips for managing more longer term absences.
Thank you, Sophie. And the reality is that an employer dealing with longer term absences will often be at the pointier end of the scale as far as risk is concerned, as it will often involve circumstances where either a workers' compensation claim has been made and has been ongoing for some time, or there's a broader factual matrix and timeline to consider. To briefly recap some of the relevant principles in relation to the long-term absences we've already discussed today, an employer can't dismiss an employee where their temporary absence does not extend past 3 months consecutively, or in a 12-month period in total where their injury or illness does not relate to the workplace. They can't dismiss an employee because of their workplace injury within any state work health and safety prohibition period, for example, 6 months in New South Wales. So that's the difference between personal injuries and workplace injuries. And they can't dismiss an employee for a discriminatory reason, such as their illness or injury, without first assessing if reasonable adjustments can be made and whether the employee can complete the inherent requirements of their role. Again, given the claims available to an employee, it is vital for an employer to be cautious with employees who have extended absences. As Sophie has outlined, there will not really be any safe or lawful way to dismiss an employee due to their illness or injury prior to the 3-month protection under the Fair Work Act passing or the relevant prohibition under the WHS legislation. Once that threshold has been passed, an employer should, in the first instance, continue to take steps to understand the employee's capacity to perform their role through consultation, as Sophie mentioned. It's likely that for an employer to comply with their obligation to provide a safe workplace, that sufficient information regarding the employee's condition would need to be obtained. This also allows an employee to properly consider any reasonable adjustments they may need to request from their employer, and the employer to consider what they can do in that regard. Where an employee does not provide sufficient medical information to allow an employer to consider these matters, and this opportunity should be given to the employee first to undertake through their usual doctor, an employer may need to direct the employee to attend an independent medical examination to understand their employee's capacity to perform their duties. This should give an employer an understanding of whether the employee can perform their role or parts of their role, or if not, when they may be able to. Where a workers' compensation claim is involved, this process would normally take place through the usual return to work processes coordinated by the insurer through the provision of certificates of capacity. Where the employee is fit for work, they should be permitted to return to their role. Where the employee doesn't have capacity to perform the inherent requirements of their role, the employer should then move to assessing whether any reasonable adjustments can be made to allow the employee to perform the inherent requirements of their role, and if not, whether the employer can safely proceed to end the employee's employment for that related inability to perform the inherent requirements. Where the employee cannot perform those inherent requirements and no reasonable adjustments can be made, this will act as a defence to any discrimination or WHS contravention in relation to a decision to dismiss. This decision and the steps taken to reach it should obviously be properly discussed with the employee and documented internally. And we would advise that as a final step before making any decision, there should be a show cause process undertaken with the employee to gather the views of the employee in relation to that proposed decision. And the purpose of that is that it supports the procedural fairness for the employee and would assist in defending against any unfair dismissal proceedings related to that decision. Sophie is now going to give us some practical tips on how employers can approach absences in the workplace, in summary of what we've been discussing today.
Thanks, Joel. Look, it's quite clear that there are a number of protections and risks involved with managing employee absences due to illness or injury. So we did just want to take this opportunity to really recap the steps that you can take to best manage absenteeism moving forward. Now, first and foremost, we do strongly recommend that you implement and maintain absenteeism policies dealing with notification procedures and requirements for the provision of medical certificates. And importantly, These policies should be enforced consistently across your business with every employee, with every absence. Now, secondly, you should consult with the ill or injured employee regularly. You can use this as an opportunity to gain more information about the employee's illness or injury, including details about their current treatment and any relevant time frame for recovery, and or their return to work. Now, as discussed earlier, we also recommend requesting the provision of medical certificates or other evidence supporting an employee's absence due to illness or injury. And where medical certificates do not provide sufficient information, or where the absence is no longer temporary, it may also be appropriate for you to seek an independent medical examination structured to address your employee's ability to perform the inherent requirements of their role. Now, finally, before taking steps to dismiss your employee on the basis of their incapacity to perform the inherent requirements of their role, you should determine whether the employee is in fact capable of performing the inherent requirements of their role with or without reasonable adjustments, and ensure that, of course, you always follow a procedurally fair process in relation to the dismissal. Now, it's clearly a very risky process to dismiss an employee in these circumstances. So the key takeaway here is that we always strongly recommend that you do seek legal advice prior to dismissing an employee on the basis of an illness or injury or an extended absence. Now, that concludes the main part of our webinar today. You may find our publication on how to hire and inspire guide useful. And you can actually download that publication via the handout section in the webinar panel if you're interested. For those who might be keen, we also have an upcoming event that may be of interest to you called Sponsoring Talent for Your New Tech Startup. And that is being held on Thursday, the 4th of May at 11 a.m. So if you're interested in attending that one, feel free to register at the link on the screen. Now, we're going to turn to answer some of your questions shortly, but whilst we give you a moment to submit them, we just wanted to take a moment to tell you a little bit about our membership. Now, LegalVision's membership is a cost-effective alternative to some of the expensive hourly rates that you can often experience with other law firms. So for an affordable monthly fee, you can receive cost certainty and all-inclusive legal services, which include unlimited document review, including drafting, amending, and reviewing various documents such as business contracts or commercial leases. It also includes unlimited advice consultations across all of our different practice areas. And we do have over 100 specialist lawyers operating in various areas from business structuring to employment disputes and many more. So if there's something you need, I'm sure we've got the lawyer to help with it. And then finally, of course, we do offer unlimited domestic trademark registration as well. Now, as a LegalVision member, you won't worry about the cost of lawyers ever again. You can really think of it as having your own in-house legal counsel. We'll take care of all the business as usual legal work so that you can get back to focusing on running your business. For those of you who are joining us who are in-house counsel, our membership can also be a cost-effective solution for outsourcing additional legal work as well. So if you are interested in learning a bit more about how our membership could help you, please feel free to request a free consultation when the survey appears at the end of this webinar. All right, we're now going to turn to the Q&A portion of this webinar. So we'll answer some of your questions. We've had quite a few come through, but we'll try and get through as many as we can. Now, Joel's going to be answering the questions. So the first question, Joel, is what do we do if we think that a medical certificate is fake?
And that's not an unusual position to be in at all. I think a lot of Australian companies and employees, if they're honest with themselves, know that there is the occasional sickie that's taken just to have the day off. The position of law is that it's very hard to challenge a medical certificate that's been properly issued by a doctor, i.e. if on the face of it, this is something that appears to be legitimate and we have no basis to really undermine that, it needs to be accepted. If an employer does think it's literally a fraudulent medical certificate, i.e. it seems like this hasn't come from a doctor, it's been completely faked by the employee for want of a better word, then the proper step to take would be to contact the medical professional who is on the medical certificate itself. And if, for example, there was no contact detail on it, you request that information from the employee, and it'd likely become pretty obvious whether or not it is a fake. But on the face of it, we do need to accept them, but there's no issue with interrogating the source of it to some degree, as long as we're being reasonable in the circumstances.
Absolutely. Thanks very much, Joel. The next question I have, which is quite a common one actually that comes up, is, so I can't dismiss an employee who is sick for any reason for the first 3 months that they are ill. Now, is that correct, Joel, or can you clarify the circumstances in which that may be possible?
That's not correct. So when we're talking about these prohibitions today around temporary absences, around workplace rights, etc., it's all based on a causal link between the decision to dismiss and that protected right under the Fair Work Act or other legislation. And so if you've got an employee who's absent or has become absent following, disciplinary processes, etc., you can still dismiss an employee as long as it's not for those prohibited reasons. And a really common one is a redundancy. You might have an employee who is out on an extended period of leave, and a business might be restructuring, the whole part of their business where that employee was employed. There's nothing to actually stop the company from going through that redundancy process. You would just want to document internally very carefully the reason for the dismissal to be able to establish that it's not because of the injury or illness, etc. And as long as no part of that decision included those reasons, then that will be a lawful reason to dismiss an employee. So it's not just about the 3 months itself, it's about what the reason for the dismissal is as well.
And I think you've hit the nail on the head with that one, Joel. And that real question is, is the reason for the dismissal because of them being sick? And that's, I guess, quite a common misconception, that there does absolutely still need to be that causal link. Now, the next question that we've had come through is, what is an example of a response to a show cause letter that may lead to a decision to dismiss being changed?
And the show cause letter is really the final step, as we explained a bit earlier, i.e. that would be where the employer has made a preliminary decision to dismiss an employee, but before finalising that decision, they want to seek the input from the employee as a matter of procedural fairness. And often, if the inherent requirements have been properly assessed prior, there aren't really matters that could change the employer's mind. But a good example is that if an employee wasn't able to complete the inherent requirements of their role at a certain point in time, but say there was medical information and evidence to suggest that, 2 or 3 weeks down the track they would be able to, and say they also have 2 to 3 weeks of annual leave accrued that they can take, it wouldn't appear to be fair in the circumstances to dismiss them for that reason. So that's an example of when a response to a show cause letter may actually result in a change in outcome. And what we're really considering there is unfair dismissal risk, i.e. if the employee raises a reason why they shouldn't be dismissed, and that's a legitimate reason, it should be given proper consideration by the employer to ensure that we're not unfairly dismissing someone.
Absolutely. Thanks, Joel. The next question is quite a common one that I have pop up, and it's, how can I stop employees making workers' compensation claims? And I know a number of employers often ask whether there's some sort of a waiver form or some way that they can avoid their employees from having that ability to make a claim. Is it possible, Joel, is the question?
It's not possible, and you shouldn't really. I'm talking about legitimate claims here. And the workers' compensation scheme is not intended to be punitive to employers. It's no fault. It doesn't mean the employer has done anything wrong. And really, what the workers' compensation scheme avoids is every employee in Australia having a general common law right to pursue claims against their employers in the common law courts. So really what it does is provides a lot of protection, not just to the employee, but to the employer, knowing that if a workers' compensation claim is made and it's accepted by their insurer, they're not going to have to be responsible for the compensation or the admin of dealing with that claim. So you certainly wouldn't want to prevent employees from making workers' compensation claims. It's a definite positive for the employee, but it's also a positive for the employer for that reason. And just to tack on something we've already mentioned a little bit earlier, you certainly wouldn't want to take any action against an employee for filing a workers' compensation claim, because that would amount to a breach of the general protections.
Absolutely. All right. The next question comes back to the query around using annual leave instead of sick leave. And the question is, if an employee has exhausted their paid sick leave, can we require them to use paid annual leave rather than unpaid sick leave?
In these circumstances, you can't generally force an employee to take annual leave, but what you'll find is practically they'll often want to, because the alternative is to be on unpaid leave. Often taking annual leave is a good midpoint that the employee and employer can agree to. It keeps the employee paid while they're out sick. It gets an annual leave liability off the employer's book. So practically, I would say that's what usually occurs. The parties agree because it's better for everyone involved, but there's no strict ability in these circumstances for an employer to force the employee to take that leave.
Absolutely. Okay. Now, the next question is, if you request a medical certificate, they refuse and request annual leave or long service leave instead, is there any recourse? Or because it's no longer personal leave, despite possibly having a personal leave balance or entitlement, is there nothing that can be done?
So there is something that can be done, and this is about following policies and also the evidence requirements under the Fair Work Act, as Sophie mentioned earlier. I.e., if they've initially said that they want to take a period of personal leave, they've then subsequently failed to provide evidence of that personal leave and tried to change it to annual leave, there'd likely be a technical ability for the employer to say, we're refusing your annual leave in the circumstances because it's reasonable for us to do so, because what you're actually trying to do is reclassify a prior period of leave because you couldn't evidence it. And so it's quite likely the employer would have the ability to say, we're not considering that annual leave, we're also not considering it paid personal leave, it was just unpaid leave on the day. But again, practically, given the fact that annual leave rolls over, annual leave is paid out at the end of employment, there's often no issue with an employer classifying it as annual leave retrospectively, because again, it's just getting a liability off their books that they would have to pay regardless at some point anyway.
Absolutely. And kind of intertwined with that, we've got another query, which again is quite a common one that does pop up. And this involves an employer that has an employee who's worked for them for over 20 years and has 40 plus weeks of unused personal leave. Now, the question is, if heaven forbid they fell ill and needed 6+ months off, are they obligated to pay personal leave for the entire period up to the limit of their accumulated sick leave?
The answer is yes, most likely. And there's a bit of a split in the courts on the final part of that query. But in the first instance, the thing to remember is they are taking unpaid personal leave, which is an entitlement under the Act. It's a right for them to take it. They can't be dismissed for that reason. But also, when we're talking about those temporary periods of absence, the 3 months under the Fair Work Act, or the total 3 months over a 12-month period, the better view in the courts right now is that excludes time when the employee was on paid personal leave. And that's by no means settled, but I would say that's the better approach, and it's also the safer approach to take. Unfortunately, this is the intention of the legislation, to protect employees in this way. It's the way that the laws are intended to operate, but yes, they would be protected in taking that leave.
Absolutely. Now, the next question is, can we negotiate a payout with the employee to reduce this risk exposure?
When we're talking about risk exposure, we're probably talking about a claim being made off the back of a decision to dismiss someone. And so whenever an employer is considering dismissing someone in these circumstances, there is risk. And even if you clear the general prohibitions, that doesn't avoid the chance that an employee perceives that they have a claim, and there may be lawyers willing to take it ahead for them. In those circumstances, while it's not necessarily recommended, you can absolutely try to negotiate an exit with an employee. And the key points to be aware of there are that it can't be forced on the employee. It has to be by genuine agreement. And really, there would have to be something ex gratia that is provided to them, i.e. it couldn't just be for paying out their annual leave, which they're already entitled to. There would need to be some component of a settlement that is actually above law. And if it is genuinely agreed to, we would absolutely recommend that it's subject to a deed of release or similar document that makes it very clear what the arrangement between the parties is. And that's normally an ex gratia payment in exchange for confidentiality and a release from future claims for the employer. Addressing that type of situation, a great time to get legal advice around it.
Absolutely, and I think that's quite an important point that you've raised there, Joel, as far as, whilst consideration may not be a necessity for something like a deed of release, there's certainly very little incentive for an employee to agree to that type of exit arrangement unless there is some incentive or payout, as you say, to basically incentivize them to enter into that deed in the first place.
Yeah,
now,
exactly.
we've had Another important question come through, and this is one that also comes up quite a bit as far as, I guess, the level of information that you can obtain about an illness. And the question is, what can be done if the employee does not want to share information about their illness with you?
And like we mentioned a bit earlier in the Q&A, a medical certificate on the face of it can't really be challenged as long as it's legitimate. And it's really about, why does the employer actually need this information? i.e., if an employee is absent for a couple of days and they have a medical certificate, then that's normally the end of it. If we're past the 3-month or 6-month period and we're trying to assess whether this employee can perform the inherent requirements of their role, that necessarily requires further information. And so the answer is, when it's lawful and reasonable to request or direct the employee to provide that further information. And if it's for the purpose of assessing their ability to perform their role, couched in the fact that we need to ensure that we're providing a safe workplace to all employees, that normally will be lawful and reasonable and be able to rely on as a direction from the employer, but not when we don't really need the information, i.e. short absences covered by a medical certificate. There's not going to be a general ability to interrogate them on the actual underlying condition too much.
Absolutely. All right. Obviously, we've had quite a lot of questions come through, but I'm just conscious of time, so we'll try and get through a couple more before we wrap up. The next question, Joel, is more relevant, I suppose, to unfair dismissal in particular. And the real question is, are there any provisions for small businesses when it comes to these issues?
Not around the employee's rights as far as the ability to take personal leave, or their protections as far as the general protections go. The only relevance to what we've discussed today, small businesses, would be there is an extended period in which an employee has to be in continuous service before they can file unfair dismissal, and that's a year for small business employers, which is fewer than 15 employees on your roster. But otherwise, no, these protections apply quite generally to small businesses as well as all other employers.
Absolutely. All right. Another question, this one does come up a fair bit as well, as far as, I guess, when you are looking to make that direction for an employee to undergo an independent medical assessment, is it necessary to have the clause in the employment contract that actually says that the employee can be referred for such an assessment, or can it be done regardless?
As lawyers that primarily advise employers, we would say that it's beneficial to have a term in the contract providing that reason. What that does is it avoids the concept of whether the direction absent that clause is lawful and reasonable, i.e. the employees contractually agreed to it. We're not making the direction as an implied term of the contract. So we would say, yes, it's best practice to include that, especially if we're in an industry where we think it's going to be regularly required to direct people to attend IMEs. Will there be pushback from employees in some circumstances? Yes. But we would say ideally it's included in the template and taken out on an exceptions basis as needed for specific employees.
Absolutely. Okay. Just having a look at some of the other questions. The next one is obviously quite relevant, I suppose, to the 3-month mark. And the real question is, after that 3-month mark expires, can termination, be progressed with as long as the process is actually procedurally fair at that point?
The answer is that you may be able to proceed with it. I.e., yes, we want to make sure we're always being procedurally fair. That protection itself only actually relates to a temporary absence or illness, i.e. the employee will still have rights under the general protections, such as a protection from being dismissed for exercising their right to take personal leave, paid personal leave. And so you still need to consider the other protections under the Act, not just the temporary absence provisions. Again, I would say any time that you're considering dismissing an employee and there are these types of facts in the background, i.e. illness, injury, etc., regardless of that 3-month time being crossed, I would still be seeking legal advice absolutely on it, because there are still other pitfalls here potentially.
For sure, absolutely. I think terminating an employee in these circumstances is never a simple matter, regardless of whether we've gone past that 3-month mark or not. The next question, Joel, is what is the safest way to deal with an employee who has exhausted all leave, i.e. their annual leave, their personal leave and their long service leave, and yet they continue to take random single days off as unpaid leave?
Well, There's no need to generally authorise unpaid leave. But again, we don't want to be dismissing an employee where they're taking that unpaid leave in the context of a temporary absence or illness, as we've discussed throughout today. So the way that you would manage that situation is obviously keeping track of the reasons for the absence and ensuring that they are complying with any procedures and treating it as a disciplinary issue where they don't comply with the relevant procedures, and otherwise keeping an eye on that prohibition period under the Fair Work Act, i.e. where it gets to the point that it's 3 months of temporary absence in any 12-month period, not including personal leave, then there would be able to be action taken at that point potentially. Again, I can't give a definitive answer because it's going to depend on all the surrounding circumstances, but yes, there are ways to manage, and it's through enforcing your own policies, keeping an eye on that 3-month threshold.
For sure, absolutely. This next question has actually come up a couple of times, but essentially the query is really around statutory declarations as evidence of personal leave versus medical certificates, and whether or not you need to accept statutory declarations. What is the general rule here, Joel? How can we treat statutory declarations, or can an employer insist on the provision of a medical certificate on each occasion?
It's under the Act. Statutory declarations are an example of the type of evidence that can be provided. So we would say it is a permissible form of evidence. Policies for our clients generally are to accept the statutory declaration as well. It's generally in line with the Fair Work Act. It's actually a much more serious legal consequence to lie on a statutory declaration than it is to get a slightly dodgy medical certificate. So I'd say it's even better evidence in some way, even if it's not evidence that's in a doctor themselves.
For sure, and I think we all know that a lot of doctors will hand out medical certificates pretty willy-nilly these days, so in some circumstances it could even be more appropriate evidence. All right, well, look, we might have one last question and then we will wrap up for the day. Joel, the question is, if an employee has been for an IME but no illness is determined, they've exhausted all leave types and continue to take personal leave, i.e. they've been employed as a full-timer on 38 hours but rarely works a full week, can an employer direct them to move to casual or part-time in terms of their employment status?
There's never going to really be an ability to direct an employee to change the status of their employment, i.e. what that would be is actual repudiation of the employment contract. There are certain terms agreed to, and in this case, one of those terms is that the employee is full-time. You can't unilaterally vary those terms and conditions, otherwise there's risk of constructive dismissal regardless. Again, it's about managing those absences in accordance with policies, keeping an eye on the 3-month threshold, but also keeping in mind that, if the full-time arrangement isn't working for this employee, you can have a discussion with them and try to get their agreement to change the status of their employment. So they can't be forced, but a frank discussion whereby it's mentioned you don't appear to be working as a full-timer would normally be working. If this arrangement isn't working for you, why don't we have a discussion about you becoming part-time or casual? And obviously that envelope can't be pushed too hard, otherwise we'll run into constructive dismissal and repudiation risk. But with their genuine agreement, you can agree to vary the terms and conditions of their employment.
Absolutely. All right, well, look, I think that's all the time we have for today, but thank you everyone for sending through your questions, and thank you, Joel, for taking the time to run through those answers. After this webinar ends, a survey will pop up for you all to complete, and we would really appreciate it if you could complete it. It only takes around 30 seconds. Please also do include your contact details if you are interested in receiving a complimentary consultation to discuss how we can help you with managing your employment needs. But other than that, that's all from us, and thank you all so much for joining us today.
Thank you, everyone.